Court will call the case of the state of Michigan versus Tommy Butler, case number 24 FB 1358.
Tiffany Woods for the people.
Allison Mueller here on behalf of Tommy Butler. Mr. Butler, can you unmute and go ahead and state your name, please?
Tommy Butler.
Thank you. All right. Mr. Butler is supposed to re-enroll in the MRT program.
Your Honor, we did go over the violation report and can address MRT. I am wondering if I could approach on a separate issue.
Sure.
Thank you.
All right, we are back on the record in this case, and I'm just going to put it on the record so it's clear. Mr. Butler apparently advised Ms. Mueller that I was his attorney back in 2011. First of all, I have no recall of that. But secondly, even if it were true, it doesn't change anything. The court rules say that you can't be the judge if you've been representing someone in the past 2 years. That's apparently over 13 years past that time or 12 years past that time. So, all right, anything further?
No, nothing in that regard, Your Honor. We are prepared to address the bond violation or the probation violations.
All right.
Your Honor, Mr. Butler is prepared to admit to the missed test and being discharged from MRT. We would like to provide an explanation to the court about what was going on.
Sir, is it true that you missed testing on March 17th, March 19th, March 24th, and April 2nd?
Yes.
Is it also true that you were discharged for MRT for non-compliance?
It was revolving the case, revolving the dropping, the drug testing is the reason.
So not in non-compliance with the MRT course, but non-compliance with testing was the reason he was discharged.
Oh, that's why they discharged you?
Yes.
Okay.
Mr. And my probation officer is a witness to that.
Okay. I find that there's a knowing and willing admission to the violation. Are you satisfied?
Yes, Judge.
Defense is satisfied as well, Your Honor.
All right. And why is he missing all these testings?
Your Honor, he had spoken with corrections. He had never done testing like this. They told him his letter was, he understood it to just be T. So he was calling every day and just checking for the letter T to be called. Apparently he has 4 letters that could be called. He now knows those. It's T, A, N, and D. And once that's cleared up, and this reflects on his newest report as well, he has been in total compliance since that issue came up. So he understands it was a misunderstanding, but it wasn't intentional that he was not testing. He was calling in every day. He just wasn't listening for all the correct letters, but he does now know and is in compliance now.
Anything from the people?
No, Judge, I would leave this up to your discretion.
And Your Honor, if I could address the recommendation.
You may.
Your Honor, we appreciate the recommendation. I would ask at this time if the court would consider not ordering the additional community service. Again, it was a misunderstanding. He has now cleared it up and has been testing as ordered. And the MRT he was attending. And again, the only reason he was discharged was because they said, hey, you have not been testing. So now that he's got the testing issue cleared up, he will get immediately re-enrolled and start going back just as he was before, or twice a week, I believe. So if the court would just give him his chance to just follow the original conditions, then we would appreciate that and ask for that.
Anything you have to say about that, Ms. Woods?
Judge, I would ask the court to follow the recommendation to have him follow all of the recommendations, including the additional 5 days of community service. Thank you.
Thank you. Mr. Butler, anything for you to say, sir?
I work 6 days a week, like 12-hour shifts, so it'll be extremely hard for me to do the community correction, to do the community service. And I mean, I was attending the class, and like I got a lot on my plate. And I mean, if I could pay a fine, I'll pay a fine if I can.
So you already owe $835 that you haven't been paying on. Are you going to be able to pay on that?
It was my understanding it was only $400.
So what was ordered was $475 in fines and costs. And then you have the probation oversight fee, bringing it to a total of $835.
Oh wow, I was not aware of that, but yes, I can start paying on that. Yes, I can.
This is what I'm gonna do. You're to re-enroll in the MRT program. I am not gonna add a full 5 days. I am gonna give you an additional day. Did you have any community service to start with? So when I first put Mr. Butler on probation back in February, I only said he had the drug test, and if he was clean, no further tests, but so that he tested positive. Is that what happened?
Your Honor, let me look.
Because he wasn't originally, I didn't have him just testing to be testing. I wanted him testing if he came up with something.
He may have never had a test, Your Honor, after that, if he was.
Did you test Mr. Butler?
Yes, I've been testing 3 times a month. Like I have no history of drug use.
But Mr. Butler, one second, Mr. Butler. My question was, you were supposed to test, so I sentenced you on February 6th, and then I told you to test within 24 hours. Did you test within 24 hours of February 6th?
Yes, I did.
And you had something in your system?
They told me that it was ethanol in my system.
Oh, you had alcohol in your system.
That's what they're saying. They said mouthwash could do that. Like I don't do any drugs, man. And I mean, ever since then, like I've been tested and nothing ever been in my system. I don't have any drug use in my system.
So is he testing for drugs and alcohol? What's his testing schedule, please?
It's both. It's $27. $27 I pay, 12 and 15 each time.
Your Honor, I pulled up his drug testing at community corrections. He is testing for both drugs and doing an ETG test. His test from May 8th until now have all been negative. He did have that positive ETG back on February 7th.
So initially he was, okay. This is what I'm gonna do. You need to re-enroll in the MRT. I'm not gonna impose the community service at this time. I am defendant to randomly test 1 time per month for alcohol. No more drug tests. So you can't use alcohol or anything like that until you get done with this case, okay? Well,
Yes, ma'am.
all right, and I'm gonna reduce it to 1 time per month. You need to get the MRT class done. And you had 12 months of probation, so if you got everything done, you could be done with probation. Your fines and your supervision fees would then come off as well, so it would reduce your fines and costs. So it behooves you to just get it done.
Okay. And can I say one thing, ma'am?
Yes, sir.
I've been trying to get enrolled into this class, like back enrolled into this class. I'm getting a runaround. I don't know how to get back enrolled into this.
Are they saying they didn't have a referral?
I called the number, and when I called the number, she told me I got to get in contact with her supervisor. I called the supervisor, and I never get an answer.
Ms. Johnson, can you make sure we send over a re-referral for him if one hasn't been sent? I don't know how we track that, but could you?
I can send a referral right now, Your Honor.
Okay, we'll send a referral back over, Mr. Butler.
And thank you, ma'am. And I didn't test twice this month, so do I test again this month?
I honestly don't control that part, as weird as it seems. They'll get the new order and they'll tell you whether you need to test again this month, okay?
Okay, and then
Probably not, but I can't say for sure. Go ahead.
Oh, and then one more thing. So my letter, so you probably won't know which letter I'm gonna be listening for either.
I don't.
Call community corrections and
they'll give you all that. What if you have a new letter and how often you need to listen, or I know you have to call every day, but whatever the letter is, they'll give you that. Okay.
Okay. Thank you, ma'am.
Thank you. Have a good day, sir.
Okay, you too.
The court will call the case of the state of Michigan versus Quantine Tolliver, case number 24S00201.
Tiffany Woods for the people.
Assistant Public Defender Davi Lieb on behalf of Ms. Tolliver. Ms. Tolliver, could you state your name, ma'am?
Quantine Tolliver.
Thank you. All right, we're here today for a review. It
Yes,
looks
Your
like
Honor.
restitution only.
Yes, Your Honor. I've discussed the proposed restitution with Ms. Tolliver, and we have no objection to that amount.
All right, and she wants to set up a payment plan?
Yes, Your Honor. Or she would like to set up a payment plan for $25 a month.
All right.
Additionally, Ms. Tolliver asked me to convey to the court at this review today that she continues to feel very sorry for the harm that occurred to the complaining witness.
Judge, I just have a question. What are they stipulating to? What amount?
The amount that was in the report that you received from Mr. Pappenhagen of
$16,000?
$195.
It was roughly $16,000, correct?
Judge, that is not the total that I have that comes up whenever I do my math. So, and I thought we were having a restitution hearing today, and is there any way that I can have a breakout room with my victim advocate before the judge rules on this?
So you don't agree with the number that was provided?
Not, yeah, I don't, judge. With the medical documents I have, my math comes out different. So I just want to make sure that my math is not off and that the correct restitution is being given.
Oh, you can chat with your victim advocate in the chat feature, but I'm not doing a breakout room right now. You two can chat. I'll pass it while you do that.
Yes, Judge.
Whoever is representing Ms. Brianna Likes, you should talk to your client because we're going to do a review of the video from today's court date, and if she's been given the middle finger to the court, she's going to be held in contempt of court, and she's going to do some.
I didn't give the middle finger to the court at all. I'm sorry if it looked like I did, but I didn't.
All right, well, I'm telling you what we're getting ready to
Yeah,
do.
and I'm also sorry about the language that was put into the chat that was not meant to go inside of the chat.
Well, it
I was
was.
responding back to a friend and it ended up going to this.
Now, please stop
And I do
talking.
apologize.
Whose client is that?
That would be mine, Your Honor, and I
Okay.
have spoken to her.
Well, I'm telling you what's getting ready to happen, so you might want to talk to her again so you fully understand, so she fully understands.
Yes, Your Honor.
The court will call the case of the state of Michigan versus Joel Jones, 17S00880.
Tiffany Woods for the people.
Sorry, Your Honor. Allison Muller here on behalf of Ms. Jones. Ms. Jones, can you state your name?
Hold on one second. Not sure if you guys can hear me.
We can, and we can see you.
Okay. Okay, perfect.
Please state your
Sorry,
name.
I'm just Joelle Jones. I'm currently at work. I apologize.
That's okay. We're here for a pretrial today.
Yes, Your Honor. It looks like Mr. Lebo and Ms. Woods have an agreement here. Ms. Woods, is this correct that the case would be dismissed if Ms. Jones pays the restitution in the amount of $423?
That's correct. And I think she can pay it pretty quickly too.
That's correct, Your Honor. We'd just be requesting a 30-day adjournment for that restitution to be paid.
All right. July 17th, 2025 at 10 a.m. 9 a.m. I'm sorry, 9 a.m. And then you will pay that and the case will be dismissed. Correct, ma'am?
Okay.
All right. Thank you. Have a good day.
Yes. Thank you so much. Have a good day.
Sorry it took you so long. It was a rough
It's
one.
okay. I understand.
All right. Thank you. Bye-bye.
Thank you. Bye-bye.
State of Michigan versus Danielle Curry McGoy, case number 22S00391.
Tiffany Woods for the
Assistant Public
people.
Defender Dav.
Tiffany Woods for the people.
Assistant Public Defender Davi Lee before Ms. Curry McGoy. Ms. Curry McGoy, could you state your name, ma'am?
Danielle Curry McGoy.
Thank you. We're back here today in this matter. Ms. McGoy had told me that she was going to make at least one payment before today's court date. I don't see that happened.
Yes, Your Honor. Ms. Curry McGoy was not able to do that. What she's explained to me is that she's currently caring 24 hours a day for her 90-year-old grandmother who is quite ill. She's looking for a placement for her so she can return to work. We're going to be requesting an adjournment of today's hearing for her to return to work and begin to make payments.
I am going to set this for a contempt hearing. Or Ms. Curry McGoy will have to show why she should not be held in contempt of court for failing to pay on her fines and costs and do jail time. I'm going to schedule this for September the 14th, 2025 at 10. Ma'am, if you haven't made a payment on your case at that point in time, yes. Okay. Then I meant August 14th. August 14th, ma'am. Where you have to show the court why you should not be held in contempt of court for failing to pay on your fines and costs. You understand that part, ma'am?
Yes, ma'am.
All right, I'll see you back on August 14th.
Thank you.
Thank you. Ms. Woods, are you still communicating on the Tolliver matter?
Yes, Judge.
All right, I am going to take a brief recess and I will be in recess for about 5 minutes. You can talk to her, try to use the restroom in that interim time period.
Thank you, Judge.
Thank you. Do you want to go in a breakout room now? Ms. Woods? Okay.
Yes, please. Thank you, Judge.
All right, the 14B District Court is back in session. The court will recall the case of the state of Michigan versus Silas Sherrod, case number 24-00234.
Yes, Your Honor. This is Matthew Mansour, Assistant Public Defender on behalf of Mr. Sherrod.
Tiffany Woods for the people.
Thank you.
Good morning, Your Honor. Ray Woodburn with A1 Bail Bonds.
Thank you. Good morning again.
Good morning. Or afternoon.
It's afternoon at this point. All right, everybody had a chance to talk. Did we have any success or no?
Yeah, Your Honor, I believe so. Thank you for that opportunity. So, Your Honor, just to recap, I spoke with Mr. Woodburn about this. On February 6th, Mr. Sherrod was given a $25,000 cash or surety bond, a warrant for $25,000 cash or surety. On March 15th, A1 bail bondsman was appointed or was hired by Mr. Sherrod, and Mr. Sherrod paid A1 bail bondsman $2,500, which was 10% of the $25,000 bond. So he posted bond. On April 30th, we were in front of Magistrate Braley, and Magistrate Braley reinstated bond, but changed it to $50,000 PR bond. So that's what his bond is now. And is all that accurate with your files as well?
Mm.
So February 6th was the
Right.
25K.
On April 30th, she reinstated the 25,000 cash or surety bond.
Correct, but it was a PR bond.
No, it was not.
Your Honor, I was in front of Magistrate Braley on that. It doesn't show on JIS, but Mr. Sherrod left.
In our file, it's
What
a
is it?
$25,000 cash bond, which was already posted. She reinstated the already posted bond.
Right, Your Honor, but I specifically remember her saying 50,000 PR bond, which okay, it is what it is. his bond right now, according to the court, is what?
$25,000 cash or the surety that was posted. We reinstated the bond he originally had, Mr. Mansour.
Well, that's where I guess I'm a little bit confused because even
Well,
on
confused, but that's what the bond is.
okay. So, all right, Your Honor. So I spoke with Mr. Woodburn, and he let me know that what he's intending to do is just be relieved as a surety from Mr. Sherrod's bond. I asked him what the ramifications of that would be. So the $2,500 that Mr. Sherrod paid, but obviously it's forfeited to A1 bail bondsman, and A1 bail bondsman is no longer a surety to this case. So we're okay with that. But
Then he goes to jail.
Yeah, see, that's the problem, Your Honor.
You're correct. That is the problem.
I'm under the impression that he could be. I'm under the impression that he's on a PR bond for $50,000 cash or surety. But if you're saying it's not, it's not. Then we're not at a resolution, Your Honor, because and if the court would, we would be okay with releasing A1 bail bondsman if the court would allow Mr. Sherrod to be on a PR bond.
How would I do when he's right now standing in front of me with a pending violation? I'm definitely not doing that.
Well, Your Honor, that's what I was hoping for. I was hoping you would, due to the fact that he has paid a bail bondsman. He showed up.
Bondsman. This court has set a bond. That bond is $25,000 cash or surety. He either posts that or he goes to jail. That we're not going to continue to discuss.
Okay, Your Honor, but he's pled on this matter.
We're not going to continue to discuss that. I can handle this one of two ways. You guys can work it out. He can not work it out and go get his bond back and then arrest the defendant, or I can just issue a warrant today. Those are the options. Your client continues to test positive for THC and amphetamines, and you want a hearing on that. We're having a hearing. He needs to have his bond. It's just that clear.
Your Honor, if I may.
You may.
Okay, Your Honor, when we posted the bond, we did it in good faith that he would be following all of your conditions. He did not. You let us know. We brought him back into custody. He was in jail. The ends of justice were thwarted as far as we are concerned. That is why we requested to be relieved for the bond. We're not understanding how we got placed back on the bond when he didn't do what he was supposed to do. We took care of the matter. I'm trying to.
Mr. What is your name again?
Mr. Woodburn, Raymond Woodburn.
Mr. Woodburn. He was seen on April 30th before the discharge came to me. I never signed a discharge, and I'm the only person that can sign a discharge. So when the magistrate saw him on April 30th, she has a note right in here saying that the bond was reinstated. She reinstated the bond.
That's why I'm trying to figure out, Your Honor, of why that would happen if we had to go out and arrest him for him not doing something that the court wanted him to do.
Because the magistrate chose to do that before we got a request for a discharge. That's what happened.
Okay, the request was sent over the very next morning, the morning of the 30th, to the court. And a phone call was
with me all you want. It's not going to change anything. I've heard what you said, and I've heard what you said. So if you want to go rearrest him and put him back in custody, then that's what you can do if that's what you say your contract says. And at that point in time, he will not have his bond reinstated because you're revoking it. But at this point, he's out. The bond was reinstated before any discharge was signed. The court speaks with this orders, and there was no order signed saying that it was discharged. So therefore it was reinstated before it was discharged. That part is done. You want to go and pick him back up? That's between y'all, and I let y'all talk about that. If he gets picked back up, the bond is still going to be the same, but they're requesting to have their bond revoked, and I will sign that.
Yes, Your
And I
Honor.
still have nothing from you, Mr. Mansour, as to why your client continues to test positive for amphetamines.
Your Honor, we're going to challenge that.
I heard you. You can do that.
We're going to challenge that, and you know, this is a kind of unfortunate, and I feel as if this is unnecessary as well at this point.
The bail bondsman wants his money back, so that's between him and whoever he decided to do his bail bondsman with.
Right? I mean, I don't. Mr.
That would be
Sherrod,
the court, Your Honor.
I'm sorry, what?
That would be the court, Your Honor.
They
We don't
can-
want to owe the court the 25,000, Your Honor. That's why I came on today.
What I said was, he chose you as his bail bondsman. That's up to you guys. Those are the questions you guys have. That's your contract.
Yes, Your Honor.
So at this point in time, the order from this court, well, the decision that I've made is I'm not going to revoke the bond today. If you pick him up and request that your bond be discharged, we will sign that discharge at that time. Otherwise, this case is on the docket for July 1st, 2025 at 11 a.m. for a hearing.
Yes, Your Honor.
All right, thank you. I need to write that new, do you want me to write the new date in? Or- Thank you. The court will call the case of the state of Michigan versus Brianna Likes, 25S00120.
Brianna Likes.
Assistant Public Defender Davey before Ms. Likes.
Ms. Woods, can you place your appearance on the record?
Tiffany Woods for the people.
All right, thank you. So we are originally here for a pretrial in this particular case. The court passed the matter when Ms. Likes' camera was off and the court was unable to see her. In the interim time period, Ms. Likes apparently turned her light on and then put in the chat, "This is bullshit. I have a different court to be at as well." So first she's cursing in the chat, and then secondly, I have an image of her giving the middle finger to the court. And as I indicated before I recalled this case, Ms. Likes is going to be found in contempt of court regarding both of those decisions that she made this morning, and she's going to do jail time. You have a right to have a hearing on the contempt proceeding. You can request that if you so choose. Mr. Lebo, what would your client like to do?
Ms. Likes would admit to both.
Ms. Likes, is it true, ma'am, that you wrote in the chat, "This is bullshit"?
It was not supposed to go to the chat. It was supposed to have went to a family member that I was responding back to, and somehow it ended up going to the chat, and it was not supposed to have. The part where I did say that I do have another court as well, that was supposed to have gone into the chat for you guys, but the other part was not supposed to have.
Now, my question was, did you put that in the chat?
No, I did not.
All right. Then we're going to have a hearing.
Ms. Likes, are you sure you want to deny putting that in the chat?
I mean, like, what else am I supposed to do? Like, it was not supposed to have went to your guys' chat. Like, so screw it. Like, it went to your guys' chat. I understand that. Like, so what are you suggesting I do?
Ms. Likes, would you like to have another breakout room with me?
Sure.
Possible.
Are we gonna do a breakout room?
You can give them the breakout room.
I'm sorry, I was waiting for you.
Are we ready to recall the Quantine Tolliver matter?
Yes, Judge.
The court will recall the matter of the state of Michigan versus Quantine Tolliver, case number 24S00201.
Tiffany Woods for the people.
I think Mr. Lebo is her attorney.
Oh, you're right, Judge. Yes. Yes, he is.
Mr. Mansour is probably still upset. So, Ms. Moeller, are you present?
Allison Mueller here on
really
behalf
hear.
of Ms. Tolliver.
Okay, thank you. Ms. Woods, did you actually have a different number?
Hold on one second.
So, Judge, I looked at the form again. I do have a different number. I don't know if we want to talk about this on the record or if we want to go in the breakout room because it's in regards to restitution. I'm fine either way, Judge. As far as the motorcycle, it looks like the victim was asking for very good condition, which would be a $12,655 range, and probation is going down to the good condition, which would be $8,075. But I still have a discrepancy, Judge, for the medical records. I didn't know if it would be productive to have Mr. Poppenhagen just pop in here and we could
He's not
review.
here this week. He's on vacation.
That's right. That's what I would ask for, Judge. I'm not saying that we would not come to a stipulation in this. We may come to a stipulation in this. I would just ask to maybe sit down with Mr. Poppenhagen when he comes back next week to review what numbers he has and why we have a different number, and then go from there. Or we can have the restitution hearing today. Whatever the judge would like to do. Those would be my two requests.
You have witnessed today?
I do have the victim is here today. He's been here. I think he's still here. He was here since 11 o'clock. Let me see if he's still here.
What's his name?
Yes, he is still here.
Oh, Mr.
Mr.
Woods is still here. Okay.
Your Honor, if we're going to have a restitution here, I would ask that that be set for a different day.
Well, I mean, it was set for today, the restitution hearing, so, but I'm willing to move it to a different day, but I thought that's what we were doing today. That's why I have Mr. Woods here.
My understanding was that the amount listed in the probation report was the amount that was being requested.
Yeah, it's not. We were requesting $23,276.39. That is including the
I'm
very
sorry,
good
Ms.
condition.
Woods, can you give me that number again? 23,000?
$23,276.39. Based on the fact that Mr. Woods's motorcycle was in fact in excellent condition, but he was willing to go down to very good condition. And every other documentation I have, Judge, is for medical records, which the defendant would be obligated to pay for as well for restitution. And that is a different amount than what Mr. Poppenhagen has. And I don't understand why those would be different, because those are very black and white. Those are co-pays, out-of-pocket expenses that the victim had to pay for everything in regards to his injuries for this accident. We're not asking for anything like weird or that shouldn't be covered by restitution. It's just medical fees and the motorcycle. That's it.
And I believe Mr. Woods was here last time and we had a very similar conversation about this. So I'm kind of confused as to why we can't get the numbers right. Does Mr. Lebo have all of the documentation that you have, Ms. Woods?
I believe he should. I can email him my exhibits right now, Judge. I was going to do that before we had our hearing. We just had such a crazy docket today that I didn't get an opportunity to do that. I usually do it before the hearing. I can.
I do have the document. I do have the documents.
So you agree that the number that they're requesting is 23,276?
No, Your Honor. The document that I have, I guess I should have been more clear. My apologies. I have the report from probation, and I have the record, and I have the bill from Trinity Health, the bill from the prosthetics company, and some copays for physical therapy, and a JD Power statement of the value of the bikes at various levels. I don't have anything that would address how much what condition the bike was actually in, or anything that in my opinion would support a greater level of restitution for the medical bills than indicated in the probation report.
The medical bills, the documentation that you have, what does that number equal to, Mr. Lee?
And I'm going to bring that up in my other screen. Just one moment, please.
And I just emailed Mr. Lebo a copy of all the medical bills that I have, which I assumed I thought he had already had.
So, Your Honor, I'm looking at the medical bills I received. There, it firstly contains a.
Mr. Lebo, I'm going to ask you to answer my direct question. What is the total number of the bills that you have?
Your Honor, I see 1,115 from Trinity Health, followed by.
Answer my question.
There's no single total listed, so I'd have to add them up, Your Honor.
And you can stop, do that, and give me that number.
Your Honor, the total I have that it adds up to is $9,450.91. However, $1,115 of that is a Trinity Health bill, and there is a letter from Trinity Health in the file indicating that that bill was waived.
So 9,000, how much?
$450.91, Your Honor.
And then you say Trinity waived 1,000. How much?
I believe it is $1,115.
So $8,339.91 is what you have documentation of?
Yes, Your Honor. And with regard to the motorcycle, I don't have anything regarding the condition of the motorcycle itself, just a listing of various values the motorcycle would have at various conditions.
All right, I understand that part. I'm
Thank
just
you.
trying to figure out why we're so off with respect to the medical bills. What's the total number you have in medical bills, Ms. Woods?
Judge, I have $18,696.39. That's well, no. Hold on a second, Judge. 1 second.
Ms. Woods, is it possible that you missed the adjustment applied portion on the bill from the prosthetics company?
From the prosthetics company, the total patient balance remaining due is $7,752.41.
Yes, we agree on that.
Okay, so I don't know what other one you're talking about where they waived $1,000.
There's a Trinity Health bill, and then followed by that, there's a letter from Trinity Health indicating your original statement balance is now 0. That would be on page 8.
I think we're looking at we're not looking at the same documents. I mean, it appears, I don't even know if we even have the same documents at this point. I mean,
Right. So it sounds like the two of you need to talk, exchange documents properly to make sure that we have everything that is supposed to be there. Then make sure that the probation agent has everything that each one of you has. And make sure we get on the same page before we come back here. Because now we have a defendant coming back, we have a victim coming back, and we're all over the place.
I agree.
I
Sorry
agree.
about that, Judge. I just assumed that we all had everything that was the same. This is my mistake.
July 17th, 2025 at 11 o'clock. Mr. Woods, I'm sorry you had to wait this entire time to not have this resolved today. Would that date work for you, Mr. Woods? You need to unmute the button, sir. I can't hear you if you're talking.
Yes, that'll work for me. Thanks for your time.
Thank you, sir. I apologize. I'll see you then.
Sounds good. Thank you.
Thank
Thank you, Your
you.
Honor.
Judge,
What would-
could you give me the exact date and time for that hearing? I'm sorry I didn't get it written down in time.
July 17th at 11:00 a.m.
Thank you.
The court will recall the matter of the state of Michigan versus Brianna Likes, case number 25S00120.
Tiffany Woods for the people.
Assistant Public Defender Davi Liu on behalf of Ms. Likes. Ms. Likes, please state your name, ma'am.
Brianna Likes.
Thank you. What would your client like to do?
Ms. Likes, at this time, would you like to admit to the contempts of court that were discussed?
Yeah.
Thank you.
Ms. Likes, please come to the camera.
Yeah.
Please.
Can you guys hear me?
Yes. Ms. Likes, is it true that you put "this is bullshit" in the chat?
Not meaning to, yes.
Is it also true that you put up a middle finger at the camera, ma'am?
Sure.
That's a yes or no. That's not a sure.
Yes.
Defendant is to complete 10 days in the Washtenaw County Jail. When does she want to turn?
And I do apologize for doing what I did, and it won't ever happen again.
Is there anything from the people on this?
Judge, I just know that she's here for a case, a child abuse case, Judge. So I know she has a young child, I believe a 4-year-old. I just would like for the defendant. I would just like for the defendant to take a look at her
She's not
behavior.
eating. She's not going to look at her behavior. Now she's eating in court.
I have a deficiency where my sugar drops really, really low, so I have to eat something because my sugar did drop really low. And I did just take it to make sure that my sugar was low, and I do apologize for that, but I have to eat something to bring my sugar back up.
I just think she's setting a poor example for her children, and she's setting a poor example for the judge and the people as to how we're going to resolve this case. And that it doesn't look like she appears to be taking any of this seriously. In court, we all wait around for the hearings, whether the hearing is scheduled at 9 or 10 or 11. It's frustrating, but it's something that as an adult, we sit quietly, we pay attention, because that's the right thing to do when you're in court. And as a mother who's setting an example for young children, I would have liked to have not have this happen, because I think that the defendant right now is setting a very poor example for everyone, including her children, Judge.
Anything from you, Mr. Lebo?
I would just ask that the court consider an alternative sanction such as community service. This perhaps an anger management program.
Defendant is to complete 10 days in the Washtenaw County Jail. I'm going to hold that in abeyance. Defendant can do an impulse control class to purge her contempt and not do jail time.
Thank you, Your Honor. I'm sure Ms. Likes very much appreciates that.
Thank you. And I do apologize for me eating, but I have to bring my sugar up.
What do we do regarding the pretrial?
Your Honor, we're going to set that matter for a bench trial, please.
For what trial?
A bench trial, Your Honor.
Are you sure that's what you want to do?
Could we approach for a moment?
Sure. All right, we're back on the record in the Brianna Likes matter. We had a chance to talk about this particular matter. I explained to the prosecutor the court's position with respect to how I view the law regarding child abuse fourth degree. The prosecutor has been fully informed on that. I am familiar with some basic outline of the allegations in this case. The court would obviously be fair with respect to this particular charge. However, I think that the prosecutor needs to speak with supervisor about the court's stance regarding the law as it comes to the child abuse fourth, and Ms. Likes needs to get her course done so she can purge her contempt. We'll put this all over to July 10th. And at that time, we'll see whether or not we need to have a waiver and whether the prosecutor would waive, given the court's position regarding child abuse fourth degree. All of those are things that, because the prosecutor would have to waive to a non-jury trial as well. So those are all the things that need to be flushed out before we are in a position to move forward. And so we'll put this to July 10th at 9:00 a.m.
Thank you, Your Honor.
Ma'am, you need to contact the probation department so they can advise you of how you can get that class taken so you can purge your contempt.
Ms. Johnson already provided that information.
I did just receive that in an email from Ms. Johnson. I'm going to forward that to Ms. Likes right now.
Thank you.
Thank you.
You're welcome. We'll see you back then. Bond is continued.
Okay, and that'll be July 10th at what time?
At 9 a.m. It's on Zoom again, ma'am. Okay.
Okay, thank you.
All right. Court is calling 2025 CR 003530, State versus Vanessa Maravete. All right, if I can have parties approach. And was there a MIC evaluation done on this? Can I have parties announced, please?
Preparing for the state of Texas.
Denny Callahan, defense.
And are you Vanessa Maravete?
Yes, ma'am.
All right, you entered a plea to injury to the elderly. According to your plea bargain agreement, the state is silent on your application. And there's an affirmative finding of family violence, and this is run concurrent with a county court cause number. All right, are there any witnesses, defense?
No, Your Honor.
All right, the court will hear your argument.
Your Honor, asks the court to take notice of the jail classification. Its weakness, of course, is that it's self-reported, but it corroborates to some degree what the MIC evaluation says. In the past, she's had mental illness problems, and less so now. And the number 2 point, Your Honor, is that the complainant in this case, in both cases, misdemeanor, your court, not interested in hurting this woman. She filed on prosecution, but there was a damage made by glass broken up against her eyes, so there was damage. She's remorseful for that. Her plan is to live with a 35-year-old friend of hers that she's known for a couple of years. There's no more contact between the boyfriend and the complainant, who is the boyfriend's grandmother. That's finished, that's over. And she doesn't plan to return to that. I asked the court to consider deferred adjudication with some type of supervision regarding where she's going to live. Nothing further, Your Honor.
All right, so let me understand this. So the facts of this case are that the elderly person was in an argument with her grandson. Is that correct?
No, Your Honor, the other way. It
says she had been arguing with her grandson and the suspect got involved.
Oh, prior to that, yes, Your Honor, but the real issue was conflict between grandma and her.
All right, you want to raise your right hand? Do you solemnly, right hand, do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Vanessa,
All right, I'm having trouble hearing you.
Louder.
Vanessa.
All right, so what is your relationship to the victim in this case?
There's no relationship anymore, but I was with her grandson,
All right, so you, and how old are you?
24.
24. And how old is the grandson?
He just turned 20 in January.
All right, and you were living with her?
I was living there for about 5 or 6 years
You were living with her?
with her and the grandson.
All right, but that's her house, right?
Yeah.
It's not the grandson's house. So you come in and you live with the grandmother and the grandson.
Yeah.
And then she gets into an argument with her grandson. And what was that argument about?
I don't remember the exact details due to the fact that I was.
I'm sorry, I can't hear you.
I don't remember the exact details because I was under the influence.
Under the influence of what?
Xanax.
All right.
Talking to my face.
So she's in an argument with her grandson, and then what do you do?
So I was, I guess, like in the middle, I guess. There was a lot of things going on due to like a lot of abuse.
You have said some things, but you haven't told me anything. So.
Yeah, Your Honor, how
Yeah.
did she get hurt?
So I got pushed into her.
No, that's not what this says. Because if you were just pushed into her, then maybe you need a jury trial. If you're saying you were just pushed into her. But that's not what it says. In the police report, it says, while on patrol in a marked vehicle, I was dispatched to the listed location for an assault in progress. The caller stated his brother and the girlfriend were arguing, and the girlfriend hit the grandmother. The caller stated the grandmother was bleeding from her head and nose. I arrived to the listed location and saw both victim 1 and O1 sitting outside on the porch. Victim 1 had visible injuries on her face and head. Victim had a small cut on the bridge of her nose, which was still bleeding. Victim had a small cut on the top of her head that was covered in blood. Victim also had a lump on the right side of her head. Victim said she had been arguing with her grandson. Victim said she had been arguing with her grandson and the suspect got involved and began to argue with her. Victim said she doesn't remember how or what she was hit with, but the suspect walked up to her and hit her. O1 said suspect had threatened to beat up the victim before. So unless you were on Xanax all the time you were at that house?
I was on Xanax for the last 2 years that I was living there.
Mhm. All right, is there anything else?
Moment, please, Your Honor. Nothing further, Your Honor.
So why were you not living with your parents?
So, and,
Sorry, I cannot hear you.
So I'm from Wisconsin and moved like 5 or
You're
6
from the
years
what?
From Wisconsin.
Okay.
And so I moved in with him and I was living with him basically for both of them because.
Did you have a job?
No.
How long have you been unemployed?
Since I got with her grandson,
And how long has that been?
about 6 years ago. 5.
So 6 years you have been unemployed. So why did you leave Wisconsin to hook your life to this person?
It's just being young.
Because your parents said they didn't like him or something, and you decided to do it anyway?
No, I just, my parents have approved, but at the time.
And how old were you when you met him?
So I was 16, but I didn't start a relationship with him until I was 18. Like about a week after I turned 18.
And how far did you go in school?
9th grade.
9th grade? Yeah, so it sounds to me like you were not listening to your parents. Did your parents want you to get your degree or no?
They did, so I was taking care of my mom. My mom is disabled, and so I was taking care of her, working at the time, and I had a part-time job going to school. And I was taking care of my mom, which she's disabled, and my little brother who's also with autism. So I felt like I had a lot on my plate, and so I chose to work instead of going to school.
And then you chose to leave them on their own because you wanted your own life.
Well, my mom had got married, and so she met her husband, which he still takes care of.
Mhm. All right, what is her criminal history?
No, I don't believe.
No felonies, Your Honor.
So the only history she has are just the 2 cases that have been before you are, which is this injured elderly and then concurrent misdemeanor you commit.
Violation of protective order? And is that with the same person?
Yes, with the same person, yes, Your
And when did that occur?
Honor. That occurred after this took place.
So she had a,
Summary of those facts if you want.
well, what date was the violation of protective order, the offense date?
December 17th, 2020. This happened November 22nd.
All right. So you want to tell me about this violation of protective order?
So I'd never like been in trouble before, so I didn't realize like whenever I didn't know how the law worked basically.
Well, I mean, if somebody tells you, if you receive an order saying that you can't contact somebody, that's how the law works. The order says you can't contact them.
Yeah.
So continue.
So I had went to have my sons, and so I was getting ready to leave, and I guess the grandson had got mad that I was getting ready to leave because I was wanting to leave him too. I was with him for 6 years, on and off abusive relationship. So because I didn't really have family here in San Antonio, it was harder for me to like just walk away from the relationship.
All right. And what is this case about? The violation of protective order?
So essentially, the same victim in this injured elderly case had concerns that there were other people in the house accusing her. So she calls 911, police respond, she lets some kids to the house and they find this defendant hiding in the closet of her boyfriend's room. She's removed from the.
All right. So obviously you knew there was a protective order because otherwise you wouldn't be hiding in the closet.
Well, I was forced into the closet. The grandson had threatened me into going into the closet.
The story you're telling me makes absolutely no sense. You have a protective order that you're not supposed to be there. You go there anyway. And now you're saying that you were hiding in the closet because the boyfriend told you to hide in the closet.
Well, he was very abusive. He had weapons and things like that. So I was very afraid of him. My family could testify to the abuse as well. They had called the police on him multiple times before all this occurred.
And when they called the police on him before, what did you do? Did you do an affidavit of non-prosecution or say, my family is not telling the truth?
So they never gave me like the option or like explain that to me how the affidavits work.
No, I mean, it's either you said yes or no, because times have changed. When the police are called out for an abusive situation, your attorney will tell you somebody's getting arrested.
Yeah. So
Now, after the
he would
fact,
get arrested, and his sister would bail him out within like a few hours. So he would be home immediately like, after being arrested. So even when he had a protective order, the first time he got arrested, he was still back and he was.
Because the protective order, the house you were staying in, that's not your house, that's his grandmother's house. You all are adults just decided to impose yourself on his grandmother. You're there, you don't have a job, and you're just living off the grandmother.
No.
And now,
Still from my family.
no, you told me that you hadn't worked in 5 years or 6 years.
Yeah, so due to the relationship, I wasn't able to work and I also didn't have, like, my birth certificate for a long time, so I had to get it sent out.
Here's the thing, I don't even know if you understand what you're saying to me. You keep changing your story. You told me you didn't have employment, that you hadn't worked for 5 to 6 years. And then now you're telling me, no, I wasn't just living off the grandmother. I had my own money. No, you didn't. You hadn't been working. I mean, you're saying, but you're telling me completely different stories. And now you're telling me that you have a 35-year-old that you're going to live with. Who is this 35-year-old?
It's a friend of mine.
Who?
I remember this happened. It's a friend of mine.
What's the name?
Jennifer.
Jennifer what?
Ramos.
And where did you meet her?
So me and her, we chatted through mutual friends and then we met, I don't know, I guess like in the neighborhood and stuff.
I'm sorry, met what?
In the neighborhood, I guess, or
So you're just meeting people in the neighborhood and now you're going to live with them? Does she have any children? What are their ages?
23, she has a 23-year-old, a 15-year-old. And then she has one that I think is like 10 or something.
All right, so if I give you probation, I'm not allowing you to live in homes that have children in them. So, and do you know who all lives in that home other than her and the children?
No, it's just them. It's just them.
Are you sure? Have you been to the house? Do you know she has a boyfriend?
She doesn't have a boyfriend.
All right, so when have you been to the house?
So I was there once. I don't remember exactly when, like I said, I was like.
Was that before or after the violation of protective order?
That was before.
All right, counsel, I don't know if she would be a good candidate for probation. I really don't know.
The remedy of sending to prison is a far worse remedy than trying to find a place for her to live, Your Honor.
Well, I know the state is asking for the minimum. And she applied for deferred adjudication.
He suggests going back to family in Wisconsin.
What I can tell you is you've applied for deferred adjudication. The state, according to the plea bargain agreement, they're asking that if I find you guilty, that your punishment be sentenced to 2 years in the prison. That's the minimum. If I grant your application for deferred adjudication and you're unsuccessful, you're looking at 10 years in the prison, potentially. Do you understand? So I can grant your application for deferred adjudication, or I can sentence you to 2 years in the prison. And the conditions that you receive are the conditions that you receive from me. There's no need to argue about the conditions that I'm gonna set for you if I grant your application. So do you want the minimum 2 years in prison, or do you want to be on deferred adjudication with the court's conditions? Are you sure? Because let me just tell you, you know yourself better than your attorney knows you, better than I know you. I know that you've been dishonest with me today, but your choices are, and you need to think long and hard about it. 2 years is the minimum. The range of punishment for this offense is anywhere from 2 to 10 years in prison. If I grant you deferred adjudication, if for some reason your deferred adjudication is revoked, you're looking at potentially 10 years in the prison and up to a $10,000 fine. So you know whether or not you can complete this successfully or not. Part of being on probation is you are not allowed to use drugs, period. There's no marijuana, there's no Xanax, none of that. And I'm not going to allow you to reside in any home with children. You're an adult, you need to get your own place, you need to stop depending on other people. Do you understand? So, do you want the 2 years in the prison or do you want deferred adjudication? All right. Yes. Yes. All right, this is what the court will do. The court is going to sentence you to 8 years deferred adjudication. There's a $1,500 fine. Time and money will run concurrently. Oh, I'm sorry, state. Oh, you're right. Thank you. State your excuse. I appreciate that. So there's a $1,500 fine probated. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. There's to be no residing with minors or anyone over the age of 55. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's an affirmative finding of family violence. There's to be no contact with Carmen Rivas or Hector Rivas. This is to run concurrent with 2025 CC 003873. Can I see the MIC evaluation again, please? Thank you. Thank you. In custody, the following: a referral to felony drug court and a TAP evaluation. If not accepted in felony drug court, follow all TAP recommendations. There should be 200 hours of community service restitution. 100 of those hours will be deemed satisfied. You're going to obtain your GED. Do you understand? And the other 100 hours will be deemed satisfied if she obtains some type of trade school certificate or higher level of education. Do you have any children?
No.
All right, and you're saying you're thinking about a transfer to Wisconsin?
Yes.
Which county?
I'm not sure the exact county, but it's in Milwaukee.
All right, let me see what Google tells us. No, they're saying it's Milwaukee County. So transfer to Milwaukee County. Field visits 1 time per month until further notice, and 90 sober meetings in 90 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful? All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, yes.
Judge, can you repeat the sober support meetings?
90,
Okay, and anger management possibly?
yes. I'll add anger management. All right, we can go off the record. Here's the thing, before you get in another relationship with anyone else, you need to get your life together and decide who you are and what you want to do in this world. You understand? She's in her world. Maybe probation will help her. Good luck.
Thank you, Judge.
You're welcome.
Right over here, man.
Yes, Judge, I'm here.
Hi. So you had filed a motion, I believe, to reconsider?
Yes, Judge, but can I be placed in a breakout room with my client real briefly?
Sure.
Thank you. And then I would like to be placed in a breakout room with the court and the prosecutor as well, once I finish talking to my client.
Oh, I will tell you, I'm unable to go to a.
I can't hear anything, Judge. Can you hear me? Hello? Should I zoom out? Should I leave and come back? I can't hear anything.
Do not zoom out. Just give me a second.
Sorry.
And I'm asking you to go to breakout room number 2. Thank you. All right, if y'all will go to breakout room number 2, please. All right, who's here on Early Hernandez? Hello, Raphael.
Good morning.
Good morning. How are you doing today?
Excellent.
Did you survive?
Better now than I am before this point.
Look, okay. It's always nice to see classmates, because in your mind, you're thinking about law school and other things.
Absolutely. Those images also flash through my mind.
All right, the court is calling 2025 CR 0018028 and 2025 CR 0018001B, State versus Early Ramirez Hernandez. Can I have parties announce?
Rafael Leal for Mr. Ramirez Hernandez.
All right, and we have an interpreter here. If you could raise your right hand, please.
Yes, sir.
Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Being Abrams, license number 2081.
And I previously asked this before, and I know the answer, but Mr. Leal, do you speak Spanish fluently?
Yes, Your.
And have you been able to communicate with your client about this hearing?
Yes, Your.
All right. Mr. Hernandez, you entered a plea of no contest in each of these cause numbers. In each of the cause numbers, you submitted an application for deferred adjudication. And each of the cause numbers, the state is silent on your application. They're asking that your punishment be assessed at a cap of 12 years. The cases are to run concurrently, and they're taking in consideration 2024 CR 00180, 2025 CR 00180B, 2024 CC 742954. And at your entering of the plea, the court informed you that if the court were to find that there was sufficient evidence to find that a weapon were used, the court would enter an affirmative finding of deadly weapon. Counsel, do you have any witnesses?
Your Honor, before we proceed, I have a mitigation expert
Yes.
that has interviewed Mr. Ramirez Hernandez, and he's asking me, this is a mitigation expert from MAC, the Management Assigned Counsel, and he asked me to request that he will need additional time to give me a report and provide more information concerning Mr. Ramirez Hernandez social history and mitigation evidence.
And how much time is he requesting?
He asking me for 30 days.
I understand you. So you want to call him and let him know, tell him that if he has already interviewed him, and this case has been, since May 30th is when the plea was entered. So if you want to call him and see if.
He says that, Judge, that he was planning on meeting with him 2 or 3 more times to properly develop that.
I'll give you to the week of July 14th, and he needs to have it done by then.
Oh, yes, absolutely.
So will he have it done by then?
I'm sure.
All right, Ms. Ferguson, recall this for July 14th. All right, thank you.
Thank you.
You're welcome. All right, who is here on Erica Arevalo? Are y'all ready to proceed?
Yes, ma'am.
Court is calling 2020 CR 5583 State versus Erica Ann Arevalo. Could I have parties announced?
I think I'll say it. Lindsay Shaw for Miss Arevalo.
And are you Miss Arevalo?
Yes, yes, ma'am.
All right, did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and State's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes,
And did you understand it?
yes.
Okay. Are you the same Erica Ann Arevalo who was placed on deferred adjudication in 2020 CR 5583 for the offense of possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams on January 13, 2021 for a period of 5 years? Is that you?
I'm sorry, so I was going off of, this might be my mistake, on the front page of the MTR, it shows just she's on for straight possession.
No, it's possession with.
Well, I see
Yeah.
that now. I'm sorry to interrupt you.
No. Do you need to confirm?
I do, because on the first page of just the MTR, not that, but the court summary, it showed that it was just straight. No, from probation, the court summary.
It's a court summary.
Ah, okay.
It should, yeah, so I only discussed the fact, I thought it was a second degree. So if I may, I'm sorry,
Yes,
Judge.
no problem. It happens. All right, we're back on the record in 2020 CR 5583 State versus Erica and Arevalo. Could I have parties reannounced, please?
Megan Galloway for the state.
Lindsay Shaw for Mr. Arevalo.
All right, Ms. Arevalo, you reviewed the motion to enter adjudication of guilt and revoke community supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes.
Did you understand it?
Yes.
Are you the same Erica Ann Arevalo who was placed on deferred adjudication in 2020 CR 5583 for the offense of possession with intent to deliver controlled substance, penalty group 1, 4 grams to 200 grams on January 13, 2021 for a period of 5 years? Is that you?
Yes.
All right, state.
The state's gonna be pursuing on the motion to supplement the motion to introduce guilt to not accomplish.
Yes.
So in violation of condition number 5 in Dare County, Texas, the defendant Erica Ann Arevalo did then and there failed to report to the supervision officer as directed for the months of January, February, March, April, May, June, July, August, September, October, November, and December 2024 in violation of condition number 5.
How do you plead to that? True or not true?
And we'll wait and abandon it.
Any objection to the waiver?
No, Judge.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 5 years or 99 years or life in prison and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5? No. Do you still wish to plead true, knowing that I could send you to prison for life?
Yes.
All right, the court will find violation of condition number 5 true. Is there a proposed agreement?
Judge, there's not. State is asking for revocation, given the defendant's being true and in compliance with reporting of conditions of probation.
All right, and defense, what are you requesting?
Judge, if you look at the court summary, probation was recommending SATIF. And in this case, we are asking that the court consider something lesser than sending Ms. Arevalo to prison. We obviously, by pleading true, she understands that it was wrong to not report for over 2 years. But I would like to point out from January of 2021 until July of 2023, she did report. She was reporting. She did complete the outpatient treatment program, and she was holding down a full-time job. That job, which she still has, well, did have until she was arrested last month. She's a full-time cashier at a Shell gas station. It's the same job she had when she got this probation. And when she stopped reporting in July of 2023, and I'm going to have her speak to the court, but she sort of got tasked with helping take care of her disabled mother. She's also been helping her grandchild, or helping take care of her 5-year-old granddaughter who has she's special needs. She has a feeding tube. There's a lot of issues going on. And so she put that above taking care of herself and doing what she was supposed to do by reporting to probation. She has no criminal history besides this felony case. She does not have any other felonies. She's never been on any other type of deferred adjudication. And she's never been to prison, obviously. So we're asking the court punish her by sending her to a treatment facility, but give her a second chance before she's gets a felony conviction and has to go to TDC. And if I would like to call Miss Arevalo.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record. All right, you may proceed.
Okay, Erica, I want you to tell the judge, why should she give you this opportunity? Why should she not revoke you and continue you on probation? Can you tell the court?
You can give me a second chance. I'm more better out there of service out there in the world than I am in prison. Never been to prison. This is actually my first time ever being locked up this long. I'm actually I did a whole 180. That was in 2020. I work now. I am actually a grandmother. I still take care of my kids. I still, my son lives with me. I help my mother because she's disabled. My brother was her provider, but then he passed away like 3 months ago. So I've been having to help my daughter with her special needs. She's blind and eats through a feeding tube. So I also have to help her. I'm a babysitter for my other daughter while I'm not working. So don't want to bet any on my record because then it would be harder for me to get a job. So if you could just put a chance on me again, I'm actually a lot better out there than I am here. I'm not even a criminal. I've never even.
No, I mean, you had drugs that you intended to deliver. They were in baggies. And what I can tell you is everybody in the box will tell me that they're better in the real world than being in prison. And one of your conditions of probation that you just testified to violating is that I ordered that you were not to have unsupervised contact with minors and you're babysitting. And the reason why I ordered that is because you have possession with intent to deliver drugs. And it was a lot of drugs.
I mean, that's not the reason why I totally dropped all of that when my grandkids came up, because how am I going to help them if I'm in prison? So that's basically.
I mean, all you had to do was report.
I mean, I've been taking care of everybody else besides myself.
So honestly, basically, you haven't been doing probation. You know, a lot of people feel as though when they're on probation, they're supposed to report and do certain things. Those are called their conditions. And they're just like, well, I know I didn't do anything on probation, but I didn't pick up any new offenses. I'm just out here living my life. If that's the case, then you're not really on probation because you're not reporting, you're not doing anything that you're supposed to do. You're just living your life. And when people come before me and they say, I know I haven't reported for over a year, which you haven't reported for over a year, but I didn't pick up any new cases. Do you know that is not really saying anything? Because there are a lot of people who are not on probation and who haven't picked up any new cases. That's like the bare minimum. Don't pick up any new cases. Don't, join a gang. So you haven't done anything on probation. What have you done?
I've been working and helping out my family and.
No, what have you done on probation?
Oh, I did that class and I was doing everything until I ended up having to move in with my mom, and then she ended up losing her housing. And I know life is like the dumbest, but actually I've been living life trying to better myself and do if you could just give me, I've never even been to prison. I'm sorry, I don't want this on my record because then it's going to be harder for me to even get a job when I do get, say you do send me. It's kind of going to be even harder for me to. So if I could, please don't send me to prison. Not prison.
I don't know anybody who's a prison person, really. But here's the thing. these are consequences to actions, right? So you're not reporting, there was a consequence to that. You could potentially end up being revoked. And I usually tell people, hey, if you think that some action you're going to take could potentially result in you going to prison, then don't do it. If you think it may happen, then don't do it. And you did it. You didn't report. Nobody's seen you for a year. Everything that you're telling me now, nobody's seen you for a year.
I mean, I've had a job for 2 years, so I mean, I wasn't on the run. I mean, I already started getting child support. Like, I already started, like, getting my income tax.
No, I mean, I understand what you're saying, but you're on probation for possession with intent to deliver drugs. That means that you have drugs for selling, and they were packaged for selling. And you were given deferred adjudication, 5 years deferred adjudication, and nobody's seen you.
Little tricky or
This is what the court is going to do. The court is going to find violation of condition number 5 true. The court is going to find you guilty. The court will revoke. I'll take into consideration that the fact that she hasn't picked up any new offenses, and I'll sentence her to 5 years in the prison, give her credit for any time served, and request the therapeutic community. And there's to be no unsupervised contact with minors. And there's a $1,500 fine, time, and money to run concurrently. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? And did you sign it? You have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Thank you, Judge.
Thank you. All right, who is here on David Graham?
Good morning.
Good morning. And this is a plea with an application?
Yes, Your Honor.
All right, probation, this is an application. It's on David Richard Graham. Court is calling 2025 CR 001088 State versus David Richard Graham. Can I have parties announced?
Roberto Ambrosino for the defense.
And are you Mr. Graham?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Graham, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Judge. Waiving the repeat or offender enhancement allegation. No objection.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Graham, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the state jail facility. The state recommends community supervision. They'll take into consideration 2024 AL 005161. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
There have not.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years. There will be random UAs and random field visits. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
No objection.
State, you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just ask that you hold the plea bargain.
All right, Mr. Graham, have you ever had any mental health diagnosis in the past?
Yes, I have.
All right, and what has that been for?
PTSD, depression, and bipolar.
All right, so I'm looking at your history just based upon what's in the indictment. Is there some reason why in the months of May you tend to fall off?
Bad time for me. I lost parents during that time. Also just brings back a lot of memories from early 90s serving.
Okay.
And just, I kind of, I guess I walked in, I am seeking help for it. I am looking to the VA for more mental health, more help. Center for Health Care has offered help for me. So I am looking into that. It's real hard for me to during certain time and months of the year. I do get my flashbacks and just vision with that problem.
So Sean, do you know if somebody from a Veterans Treatment Court can come up? All right, so we're gonna see if somebody from Veterans Treatment Court can perhaps help you, all right?
Okay.
And they can get you in touch and be a liaison between you and your treatment. And I'll see if maybe Veterans Treatment Court will accept him into their program. Because I don't have the manpower to be able to see you on a weekly basis or on a daily basis. But they'll be able to work with you and make sure that if there are any issues or anything you want to discuss, they'll make sure that you have someone that you can discuss that with, okay? All right, do you have any children?
I have one 15-year-old with their mother. I have no contact.
All right, do you have any other family support?
Basically, I have nephews, but it's just considering my actions in the past and what things are gone, I've kind of pushed myself away from my family due to that reason.
Okay.
Is I know at times I am very unstable.
Okay.
And I just prefer to not endanger anybody else, keep to myself.
All right, and so this apartment where you were staying at, if you were released, do you have a place to stay, or that's going to be something that you'll need to work out?
That's gonna have to work out now. In fact, I was possibly going to. I need to get out of sleep. That's number one in my book. That's where a lot of bad things. I need to get in the country where it's less, I guess, less people to see, want to come find more real, somewhere in an open area. And I have a spot that I'm looking.
Okay.
I was looking at until I got arrested. But I need to get back to these people and talk with them, to work with them about my check, my pension I received and all.
All right, so when we're going to have somebody from VA come down to speak to you, and I'm going to recommend that you be referred to the Veterans Treatment Court. So they're gonna come and speak to you. I'm gonna send it to you now, and they're gonna come speak to you. And if there's anything else that you need, they'll let me know, okay?
Okay.
And they'll be able to confer with you and make sure that you
Okay, I just got
have the
out,
right people.
I just got out of a rehab facility that the VA has. in
Okay.
Serena. So I just got out of there.
All right. So this is what I'm gonna do. There's gonna be regular reporting by Zoom or in person, regular random UAs. There's gonna be a referral to Veterans Treatment Court. And if he's not accepted, then we'll do a referral to the mental health court. Counsel with the mental health court, it's a pretrial diversion program. So you can speak to them if he's not accepted and just let them know that if he is accepted, I'm sure the state will have no objection to filing a motion for new trial and I'll grant it. And that way he can be in that program.
Okay, what about for the Center for Healthcare, ma'am?
Oh, they'll take all, they're gonna, Veterans Treatment Court will help you with that.
Okay, because where I was staying out, being homeless and stuff, I ran across two people that worked there. They gave me their numbers and they turned around and told me just to let the courts know that I already kind of have a shoot in with them. I just need to get back, once again.
No, they'll help you with that, okay?
Okay, I have their numbers, like I said, I'm just, want to
Yes.
confirm that, you know, that you have that there, then I'm gonna go to.
Okay,
As soon as I get released from here, I got the direct numbers, not the office number.
all
I
right,
have the people's direct numbers to call them.
okay.
So I can work with this.
All right, thank you for letting me know. All right, and there, if not accepted to Veterans Treatment Court, then a referral to Mental Health Court. Sentence him to 2 years in the state jail facility, suspended and probated for 4 years. Take in consideration 2024 AL 005151. There will be field visits 1 time per month until accepted in VTC or mental health court. TAP evaluation. That can be out of custody. You're gonna have to make sure that you make all of these appointments. If you don't, a warrant is gonna be issued and then they may end up being done in custody. You understand?
Ma'am.
And we can do a MIC evaluation. And the MIC evaluation, Ms. Abrams, only if VTC doesn't accept him. Probation, is there anything else he needs? All right, proof of, I'm sorry.
Yeah,
All right,
okay,
proof
but
of employment or SSI
yeah, let me just.
within 45 days. You just provide that proof to them, okay?
Had a problem.
And if he doesn't, and if he's employed, there's to be no employment as a home healthcare provider or with minors. I'm not gonna give him any community service hours.
Thank you.
He's served his country, and I think the issue with him, we need to focus on his mental health, and there are gonna be a lot of appointments for him.
Thank you.
But I am gonna make you do sober meetings,
That's fine.
because you need that. So we'll do 60 sober meetings in 60 days. Is there anything else, probation? Is there anything else you need from the court?
No, ma'am. Thank you.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, sir.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so we can go off the record. Probation, they want you to be successful. Your attorney wants you to be successful. State wants you to be successful. I want you to be successful. If I didn't think you could do it, I wouldn't have followed this plea bargain agreement.
Yes.
So if you need help with something, you're gonna have to pick up the phone and call someone, because we can't help you if we don't know about it, all right?
Yes, ma'am.
And when you reach out to probation, if you feel they're not addressing the issue, you can always come back to court, okay?
Yes, ma'am.
So I'm gonna have you remain out here. Somebody from Veterans Treatment Court is gonna come and speak to you.
Thank you, ma'am.
And then counsel, if you can look into speaking with mental health court to let them know that we'll do a motion for new trial if they're going to accept him.
Okay.
All right, thank you.
Yes.
Yes. All right, who is here on Ronnie Benson? All right, is this a motion to revoke? Are you both parties ready to proceed on the motion to revoke?
Yes, Judge.
Yes, Your Honor.
All right, the court is calling 2020 CR 8253W State versus Ronnie Benson. Can I have parties announced, please?
Harrison, stay.
Rafael Leal for Mr. Benson.
And are you Ronnie Benson? Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, but I couldn't read it because I didn't have my reading glasses, so
Oh,
he explained it to me. But I told him, I said, I already been tried on this case.
no, you have not. So what has happened is you're on probation for driving while intoxicated third or more. And there are conditions that are set for your probation. So technically, you pled to the DWI, so that's not what you're here for today. You're not here for a DWI from 2020. What you're here for is they're saying that while you were on probation, you did not do something or you violated some condition.
Yes, it was my doctor, he changed my medicine and I came.
No. Here's the thing. That doesn't address these issues because none of these allegations in the motion has anything to do about your doctor. It has different conditions. So what's going to end up happening if both parties are ready to proceed, the state is going to read what they said you did not do. You're going to enter a plea of true or not true, and then I'll make a decision. Do you understand? All right. So are you the same Ronnie Benson who was placed on community supervision in 2020 CR 8253W for the offense of driving while intoxicated third or more on August 27, 2020 for a term of 6 years? Is that you?
Yes, ma'am.
All right, state.
On about the 17th day of March 2025 in Garrett County, Texas, the defendant Ronnie Benson is headed there about to submit to the testing as directed by the court / supervision officer in violation of condition number 2.
How do you plead to that? True or not true?
True.
State waives the remaining violation obligation.
Any objections to the waivers?
No, Your Honor.
All right, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 6 years in the prison and up to a $1,500 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. Is there a proposed agreement?
Yes, Judge. Amend conditions. Deny the motion. Amend conditions for weekly UAs for 30 days, followed by monthly thereafter. Intensive outpatient with PCC SCD and documented sober support meetings as recommended by TAM.
All right, so what has he done on probation?
Judge, he has been, aside from those violations, he has been compliant to a substantial amount of the conditions. He is, for all practical purposes, not employed where he's paid with money. He's paid with by giving him a place to live and kind of like room and board. That's how he gets paid, and he gets SSI of $900 a month. So that's one of he's behind in payments, but that's his economic situation. Most of the, aside from those allegations, Judge, he has a bunch of tests that are negative. And we're asking that the court agree with the recommendation and give him those conditions and place him back on regular supervision.
Probation?
Judge, Mr. Benson was in drug court from May of 2021 to March of 2023. Completion of that program, he did the DWI intervention. He's gone through one round of outpatient treatment. He's finished his victim impact panel. He was on the transdermal alcohol monitor. He finished that. He did the required sober support meetings. He has completed most of the terms of his probation. It's just the, with these slight violations.
You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Ronnie Benson,
All right, Mr. Benson, do you want to go to prison?
no ma'am.
Then why are you not doing what's required?
I've been doing everything they asked me to do.
But why didn't you submit to the drug testing?
I did everything I could.
No. They said, and you just pled true to not testing. Why didn't you test?
I probably didn't have a way,
Did you call somebody and say, I don't have a way to come in to test?
I believe I told the judge.
No. Because I'm the judge. You didn't tell me.
Oh, I know it's good for.
All right, but you've completed drug court. That's why you're back here. You're back here and your case was not, usually they will terminate your probation when you complete drug court. But the reason why they didn't in your case is because there is no early termination for DWIs.
That's right.
So
I did everything they asked me.
they asked you to submit a UA and you didn't. So my question is, why didn't you do that?
I probably didn't have a way, or I didn't have the money.
Did you call somebody?
I called, well, not here, I didn't. But when I was in drug court, I did.
All right, probation, what are you all asking for?
Judge, this is state, educated, for weekly UA for 30 days, monthly thereafter, into outpatient treatment and documented sober support.
How often are you doing sober support meetings before you were taken into custody?
I was just doing probation and doing UA and reporting every month.
All right, so here's the thing. When you're on probation and you have a drug or alcohol problem, you have to stay vigilant. Otherwise, you're going to backslide. And it starts by missing a UA and not telling somebody about it, not picking up the phone and giving them a reason why you may not be able to make it. And then the next thing you know, you look up and you're back where you were before. And that's what's happening to you. Now, if you want to go to prison, I will send you to prison today for 2 years. You'll be done. You'll get credit for any time that you successfully completed inpatient treatment. Otherwise, you're going to finish this probation. What would you prefer?
Stay free.
All right, there's going to be intensive outpatient treatment, 90 sober meetings in 90 days. And there will be regular UAs. And he's to continue with ignition interlock until further notice. Yes.
I don't know that it has interlock. I see that it has a portable device.
Do you have a vehicle?
I have a vehicle, but it's not running.
All right, you need to provide proof of that. And with an affidavit of non-driving and proof of an operable vehicle, then he can do the portable monitoring device until further notice. Is there anything else you need from the court? You better do better. And remember all of the tools that you have been given to not backslide. You understand? People, places, and things, and you have to take accountability. All right? All right, good luck to you in this court. If you need something, you can call probation. If you feel they're not addressing it, you can always come back. All right, where's Anita? All right, let's take your case. All right. And you're here for, oh, could you please bring him back? All right, if you'll have a seat. And what's your client's name?
Jaylen Ross, Judge.
All right, could I have his file, please?
Who is that?
Jaylen Ross.
Jaylen Ross.
And I see it's raining.
Oh, yeah, I got poured from, yeah, I got wet from head to toe. But I was having like a lot of problems, like last night, my power kept going out, it went out like 5 times. And then like this morning, I couldn't hear you, so I apologize, but
No problem.
I did confer with the state and we.
The motions that she just filed this morning, we haven't had proper time to review them, and we'll give this at least 3 days before those motions are heard.
Oh, we can go for it. It's a motion to
No,
reconsider.
I wanted to start to talk about it in chambers if that's possible.
All right, so here's the thing. Once I have motions to reconsider, I always tell people,
Excuse me, it went mute and I can't hear or see anybody.
yes, I know it's mute.
Oh,
Let me unmute. All right, so I'm not gonna reconsider his sentence. Unless there's some evidence where he should have a motion for new trial.
All right,
not
that's
gonna-
correct, Judge. So I filed a motion to withdraw the plea, and I've also filed a verified motion to recuse.
All right, I don't have the motion to withdraw before me.
I have copies. So
And
that's
you
why I
want to
wanted-
withdraw?
No, I'm not asking to withdraw as his lawyer. I'm asking for the court to be recused.
All right, well, what I can tell you is I'm not reconsidering any sentencing. And if you want a motion to recuse, another judge will have to hear that.
That's correct, Judge. So I'm asking that it be, and I know the state's asking for a few more days to properly.
Oh, there's
prepare.
nothing for me to do on the case once you file that. All right, thank you.
All right, thank you, Judge.
You're welcome.
Nothing?
Can Mr. Ross be excused?
He can be excused.
Okay, thank you for your time.
All right, thank you. All right, who's here on Kaya Medellin? All right, who's here on Isaiah Story? All right, and this is the last case we're taking before, everything else will come back this afternoon. Court is calling 2025 CR 0000582, State versus Isaiah Story. Can I have parties announced?
Rick Pena for the state of Texas.
Howdy, Joe Stenberg representing the defendant Isaiah Story.
All right, is there any applications in this case?
Any what?
Applications for deferred or?
No.
Okay.
Is it to do?
All right, and are you Mr. Story?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, and
Court will find that the state is in compliance with discovery. Mr. Story, did you review the true bill of indictment with your attorney? Did you understand it?
yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Mr. Story, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand your charge with sexual assault as a second-degree felony? Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He had.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Story, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's an 8-year sentence, a $1,500 fine. There are no applications. There's to be Chapter 62 compliance and no contact with the complainant. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
As the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
Not really. There was a request for bond, but never mind.
All right, then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
Yes, Your Honor, this time state the evidence states exhibit 1 with all attachments.
And state, have you spoken to the complainant?
Yes, we have, Your Honor.
All right, thank you. You may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes.
Anything you wish to say on behalf of your client?
Other than the fact that, keep in mind, he was 17 at the time, thinking with what I call the wrong head.
Okay. All right, the court will find you guilty. The court will sentence you, because you're saying he was 17 at the
Yes.
time. But in the police report, it says that they are more than 3 years apart, but
Well, the
joint
girl
collection.
was 14.
Well, according to, just 1 second, we're going to go off the record for a moment. This is what the court is going to do. The court is going to find you guilty. The court is going to sentence you to 6 years in the prison, give you credit for any time served. There's a $1,500 fine, time and money to run concurrent. There's going to be Chapter 62 registration and no contact with the complainant and no contact with minors. And let me just tell you the reason why I did the 6 years, because I realize how close in age you both are. All right? And that you're 17, okay? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you're going to need to speak to an attorney, and you're going to have to register for the rest of your life. Do you understand?
Yes.
All right, good luck to you.
Can I put on the record, I take back some of the things I said about them.
You're always a hoot.
Thank you very much, Your Honor.
You're welcome.
May I be excused?
Yes.